Okay, let me, I will start so long. We are still admitting some people, but welcome, very welcome to our participants on Zoom, but also participants on Facebook, to our webinar today that's part of our SAIFAC online forum. I am Ms. Baru, and I'm the Acting Director, Deputy Director of SAIFAC. And today we're going to look at the horizontal application of the Constitution and children's rights, and specifically discuss AB versus Pridwin Preparatory School. So today, before I introduce our panel, this is quite a fascinating story. It feels like a story that you're reading, but basically about a school, a private school, and its relationship with parents, but then that has an I wouldn't say an indirect effect, but that directly impacts on the children. So I'm sure the participants will also speak to some of the key aspects that is addressed in this, in the judgment itself. But just a little, I'm not sure if the panelists are going to go into detail about the facts, but it's basically about parents, and very specifically the father that was a bit aided also by the mom, with a very toxic relationship with Pridwin School. And the courts also, how they describe this relationship that became increasingly toxic, is that it was overbearing, obsessive, harassment, etc.
Oh,
and let me just put on mute there. Here we go. Yeah, so the impact of the eventual result of this deteriorating relationship between the school and the parents was that the parent contract was terminated. But then also one of the core things that this judgment turned on was specifically the failure to give the parents a right to a hearing, but then also the children. And that's something specifically that Justice Kampepe looked at, this failure to hear the children. And in the larger scheme of things, that everyone started focusing on the behavior of the parents versus the school versus the parents, and then the children being impacted quite seriously in this. So the first speaker will be Karabo Ozah. She is the director of the Center for Child Law at the University of Pretoria. She's also an extraordinary lecturer there. And she has appeared quite regularly before the High Court, but as well as the Constitutional Court. And the Center for Child Law was one of the two amicus curiae that was also appeared in this case, in the judgment before the Constitutional Court. Meghan Finn and Dr. Charissa Fawole, I will introduce just before they speak. So I will ask you, Karabo, take it away and lead us through, because before you do, just some of the questions that you're going to look at is very specifically how the court, the Constitutional Court, but also the other courts, how they applied the Constitution horizontally when it was a contract between the parents of a private school and the private school vice versa. So how did this find application horizontally, specifically relating to Section 28, subsection 2, and with regards to the best interests of the child, and then the right to a basic education, Section 29, 1A. So we are going to look at this throughout, and there will also be questions, and I see a number of our participants are, I think we have a keen interest in, we'd have some valuable insights to provide and have some very thought-provoking questions. So Karabo, over to you.
Thank you very much, Ms. Ba. Good afternoon, everyone, and thank you to SAIFAC for the opportunity to be part of this. Thank you, Charissa, for inviting me. I do hope that my contribution to the discussion will enrich what we're trying to get out of what the judgment means. And I think, you know, at the end of the day, when we finish the discussion, we must reflect about what does the judgment mean, and particularly whether it has made any impact to how the private schools in particular are approaching these issues of when they have gotten to a point where they wish to terminate a contract with parents, and actually particularly how they now, if they are considering really the impact of those actions on the children. So as Mispa said, this is really a story about you know, the kind of disagreements that started with the parents and the school, and it, you know, mostly about the kind of the parents' expectations of what the school should be doing pertaining to sports. Looks like the father was a great sports fanatic, and he felt like his children were not really being coached in a way that will make them the next, you know, best cricketers in the country and the next soccer players, best soccer players in the country. And that started all those disagreements where he would interfere with what is happening on the sports field, and to an extent of, in one instance where he brought somebody from an outside you know, organization as a potential coach or a person to come and tell the school how they should be coaching the children when it comes to soccer. So the parents had signed the contracts, and the contracts are important because obviously that's what led to the termination of the relationship. They had signed the school contracts that had a clause that is clause 9 in the contract that allowed the school to terminate the agreement for either on conduct of the children or of conduct on the parents. So having struggled for about a year or more even with trying to rein in the parents who are the applicants in this case, the school came to a decision that they will no longer be able to keep the children in the school because of how the parents were behaving. When you read the judgments and when you read even the papers, I remember I read the High Court papers, but we were not involved in the High Court. You know, there's nothing in there about the conduct of the children, and I think that's why you know, the judgments that particularly focus on how children will be affected by this decision is very important, because I think the children were wondering why they're being chased out of the school because they didn't do anything wrong. And I don't think the parents also understood, you know, through their conduct, how they were affecting their children. Maybe one day the children will write a book about the experience of this. So then in June 2016, then that's when the school headmaster decided that they're terminating the contract. Obviously, in the papers, there's a lot of information about how the school was trying to also assist the parents to apply at other schools, and the delays in relation to that. And also there was a dispute about, at one point the parents had accepted that we will go, and then we would just need time to find a school. However, when push came to shove, the parents decided to take the school to court, and then you had the litigation in the High Court where the school obviously defended it, and the parents were unsuccessful in trying to argue for their children to remain in the school, and particularly in that judgment, obviously in relation to whether there should have been more consideration to the best interests of children before the termination. The judge kind of expressing the fact that you cannot expect that in every contract that's signed by a parent, you'll have to, every time there's a child involved in any situation. I think in the judgment, you even find an example about if a child went to a dentist and something went wrong, and how the dentist will have to have considered the best interest of the child. So the judgment clearly kind of taking the route that it was a contractual agreement between the parents and the school, and it came to an end because of the conduct of the parents, and that's where it kind of begins and ends. Equal Education Law Center was an amicus there, and I saw Norina is here. She was still at Equal Education at that time, and they went into the High Court to actually argue as amicus the fact that, you know, this contract does not only apply in relation to what we would call the Rolls-Royce private schools, but it also affects children in these low fee independent schools that we have quite a lot in the country, and that those schools will also have a clause 9.3 in their in their contracts. And so it was important for the court to deal with the aspect of whether terminating the contracts without considering what is in the best interest of the child was the appropriate way. Obviously, the school always maintained that they did consider the best interest of the child. The school principal said that he sat in his office on his own and managed to determine what would be in the best interest of the children, and based on it, based on the interest of the other children in the school, and based on the interest of the school, he came to the decision then to terminate the contract. Then the matter went to the Supreme Court of Appeal, where the parents kind of strengthened their arguments relating to best interest and the right to education, and how they should have been afforded an opportunity for their children views to be considered before the contract was terminated, and that the failure to do that was something that was unconstitutional, and also that clause 9.3 itself was unconstitutional. They didn't succeed in the Supreme Court, as we all know. There was a dissent by Judge Justice Mutsumi in the Supreme Court, which most of us looked at and kind of agreed with, and obviously then it ended up in the Constitutional Court. So our center got involved in the Constitutional Court to make arguments, particularly in relation to Section 28.2 and what it means, and particularly highlighting the fact that it not only has a substantive element, but it has a procedural element, which the High Court and the Supreme Court had missed, and I'll come back to that. We also made arguments about the Section 29 1A, as has been mentioned, and read together with Section 29.3. The school and ISASA had argued that they were not providing a basic education in terms of Section 29.3. 29.1A, and that what they were providing then did not fall within that ambit. So they were different. They were just under Section 29.3. And you will see in the judgment that, particularly the judgment of Justice Theron, she addresses that, and even Justice Nichols kind of says that it cannot be the correct interpretation, because it's not about whether you're private or public. Section 29.1A has to do with the level of education that you're providing. Even if your basic education is superior to a public school, it still is a basic education. And then obviously there was the arguments particularly pertaining to clause 9.3, and whether it allowed, whether it was constitutional for a clause like that allowed the school to terminate the contract without considering properly the best interest of the child. Obviously, there was argument about whether that meant that there has to be a hearing, every time you're considering terminating these kind of contracts. And I'll come back to that aspect again. So we made submissions, obviously, in relation to Section 28.2, making it very clear that it had those two components of procedural and substantive. And particularly, we had not, up to this judgment, had a clear judgment that said, that highlighted the procedural aspects. We know we have reached judgments like jurisprudence on what Section 28.2 means, the content of it, S versus AM, Fitzpatrick, AD, and another. We have, quite a lot of judgments. So we went in particularly to highlight the procedural aspect, and relying also on the UNCRC and the general comment on best interest that clearly says that, there must be procedural guarantees in relation to how you consider the best interest of the child, and there must be justification of the decision. So you must be able to show what you took into account. So the fact that the school principal said, I considered best interest and versus the best interest of the broader school community does not cut it. You have to break it down and say, how did you do that? And also, how do you consider the best interest of a child without having had input from that particular child? Those are all the aspects that pertain to the procedural element of best interest. So what we also said was that we're not arguing that Section 28.2 creates an obligation for a hearing, all the time in every circumstances where a child's best interests are at stake. However, that it creates an obligation to have those best interests be of paramount consideration. At times, it might need that there should be a hearing. At times, there may be submissions that need to be made. That is the content kind of the procedural aspect of it. Importantly, in relation to Section 29, and I'll just say Section 29 broadly, of the Constitution pertaining to access to education, So we made the argument that children who are in private institutes and schools have the same rights as children who are in government schools. Your starting point should be that all children have enjoy all the rights in the Constitution, and also that they have a right not to be subject to unfair discrimination, and more importantly, again, they have a right to due process. So when a private institution takes a decision that impacts on children, it must do so in a child-centered manner. The fact that the private institution does not absolve them of this. And we relied on the, just as we're about to go to the Constitutional Court, the John Wesley judgment came out, and most of you might be familiar with it, that it has quite, even though it's a high court judgment, obviously it has quite a lot of kind of nice quotations about the obligations of private schools. And in one of them, the judge says that independent schools must act in a manner that minimizes the negative impact of their actions on the ability of learners to attend school. So while they may be entitled to invoke authority to exclude learners, a fair procedure must be followed. The exclusion must also be for a fair reason, taking into account what is in the best interest of a child. In this regard, it should not matter whether the school is an independent school or a public school. This must apply regardless of whether such exclusion relates to the child's conduct or any breaches by its guardian, by the child's guardians or parents. So we relied on this, very progressive judgment that had come out of the High Court. And furthermore, we also say that independent school cannot exclude the constitutional rights that are in, particularly the right to education, as in Section 29(1)(a), from the assessment and determinations of the best interests of the learner. So you have to read Section 29(3), which is a right to be established as independent institutes. You have to read it together with Section 29(1)(a). And as I mentioned, they were trying to say that they're not covered by Section 29(1)(a), and in that way, kind of moving away from whether they could be bound. And I think Ms. Pam mentioned this issue of horizontal application. So they were trying to avoid that we're doing something different here. You cannot bring us within this ambit, and we are independent in a way, kind of keep themselves elite, and as I say, have a constitutional free zone to some extent. And we know that in the judgment, the judges said they didn't agree with that. And we had made the argument that they cannot operate outside the obligations imposed by the Constitution. So they have an obligation to uphold the best interests of the children. And then the last argument we made pertained to that clause 9.3 itself. And when we made the arguments in our submissions, we highlighted the fact that there were rights that were intersecting here. So there's the right of the school and the parents to contract with each other. There's the interest of the school to provide the right to basic education to children. Then there's the interest of the children to receive basic education and to have their best interests protected. So we said that Pridwin and other independent schools operate as a going concern and also provide an education. So their main concern is providing education. They exist to provide education and giving learners positive learning experience. So insofar as that is concerned, the contracts that they enter into cannot be perceived or held out to be independent of the learners. So, there was this argument as if the contract is just between us and the parents, but you're contracting in relation to children, and children are the people who are going to be in your space, who you have an obligation to give an education to. So you cannot then want to have an approach that kind of absolves you of that. So that was very central to highlight that. So we said that failing to follow a clear, considered process where you're determining what is in the best interest of the child in the process of terminating the contract in terms of section, clause 9.3 was unreasonable and did not protect did not accord with what is in the best interest of the child. And also, kind of linking it with S versus M, there's a quotation there about children not being, not having to sink and swim with their parents, that, there was nothing to show that the children's conduct adversely affected the school in any manner or other learners. So they to come to the conclusion that it was in the best interest of the learners, other learners in the school community, that their interests outweigh those of the two children who we refer to as DB and EB in the judgment, without substantial reasoning that was unreasonable. You cannot say, you see, you know, and it's very important because before we started earlier today, I tried to find online the contracts and see if there's been any changes, and the ones that were popping up that I could open from the different private schools, they still have clause 9.3 as it read. And when you read it, you will see you become uncomfortable by how there's quite an emphasis of the interest of the school community and the school, and the discretion that's given to the head or the principal of the school. Those still remain, and we can talk about what can we do about those. But the approach, kind of, when you read the sections, obviously they will say the interest of the child, but moreover the interest of other children in the school and the school community. So it's crafted in a way that kind of leads to that approach that minimizes the proper consideration of the best interest of children who face an exclusion, and that is problematic, because that's exactly what happened in Pridwin. You know, it was that your parents are so difficult, they've embarrassed us, they've embarrassed other learners, and they become, you know, this way, and it doesn't matter, because we have this clause, we're going to now exclude you, which is something that is problematic. So yes, so that was you know, the arguments we made, and then if you go into the judgments, obviously we know that there is the Nichols judgment, the Theron judgment, the Kampepe judgment, and also then the one from Justice Froneman and Justice Cameron, which I think we're trying to kind of find a middle ground between the first and the second one. I know Charissa is going to focus on the Kampepe one that focuses on the best interests of children, but I do think that Justice Theron kind of brings the balance as well in relation to the horizontal application and reading then the section 29 1A together with best interests. In a way that upholds and makes it clear that independent schools have an obligation to children in relation to how they conduct themselves and how they make decisions that impact on the children who are learners in their schools. What I wanted to then kind of end with is what I just mentioned now. So I feel guilty myself that we haven't done any active kind of follow-up work. When the judgment came out last year, we had thought that we were going to write to ISASA and other private school, independent school bodies to ask if they will be reviewing their clauses, but we never really got around to that. And as I say, when I read today, there are contracts that dated, you know, June 2021, and they still have that similar clause. Quite a lot of them have that similar clause. There is no really anything added in relation to procedural issues. There's nothing really added in relation to maybe highlighting the obligation to really consider the best interest of the children in a way that is substantive. And I don't know, I mean, you know, also, you know, how does one monitor them? Because the only way you'll know that they're following it in practice will be if we get or following or not following is if you end up with a dispute coming to court again, that they haven't really kind of aligned themselves with what the Constitutional Court judgment has said. Yeah, so maybe let me end there and give the other presenters an opportunity, and then we can then have a discussion about this. Thank you.
Thank you very much, Karabo. That was quite insightful. And I definitely, it is worrisome that clause 9.3 is still in various contracts between parents and the private or independent schools. And also just it's also quite significant, I think, that the Constitutional Court for the first time could really flesh out the relationship between children and parents and private schools, and especially children's rights. So that was very, very interesting. Thank you for your insights there. Then our next speaker is Meghan Finn, and Meghan Finn is a lecturer in the Department of Public Law, an nGAP lecturer in the University of Johannesburg. And I've also worked with her, so I've worked with her personally, and then also at SAIFAC. She was also a clerk for Justice van der Westhuizen and at the Constitutional Court, and has practiced for quite some time as an advocate. Now, her PhD that she is currently busy with Professor Kathy Albertine at WITS focuses very specifically on the duties of private persons and the right to equality. So I suspect she is going to focus quite a lot on the horizontal application of the private parties, for example, private schools. So Meghan, over to you.
Great, thank you so much, Ms. Ver. And I'm going to try and share my screen. So please let me know if at any point it sort of glitches. But just to say thanks so much for organizing this conference. I think the Pridwin Judgment is really, really important and significant for a whole host of reasons. And it's wonderful to have, I can see people in the virtual room here who were really instrumental in bringing that case to court. Like Karabo, who really appreciated your insights in terms of, fusing the litigation with the court's prior jurisprudence on children's rights and the best interest principle. As Ms. said, my focus today is going to be on horizontal applications. So I'm not really going to speak so much about section 28 or 29, but I'm really going to be looking at the approach that the judgments took to the horizontal application of the Bill of Rights. And so I'm drawing, in this presentation today, I'm drawing on a note that I wrote that was published in SALJ at the end of last year. And basically, my central argument is, all four judgments of the Constitutional Court agreed that the school could not cancel a contract without fair procedure. And by rejecting the idea that the independent schooling sector is insulated from constitutional duties, the Constitutional Court's judgment achieves a vital outcome. So it again recognizes that private persons can wield great and entrenched power and profoundly impair the realization of rights. And this is really an important corrective to the restrictive approach that was taken by the SCA and the High Court. But while the outcome was welcome, the court's reasoning rests on some shaky foundations, at least as far as horizontal application goes. And today I'm really going to make three main points here, which is first, that the majority judgment unfortunately perpetuates the idea that there are parallel systems of law, that there's a system of contract law that is relatively insulated and not subject to the same kind of scrutiny. So that's the first point. The second point is that the test that is applicable to justify private persons' infringements of rights is now a little uncertain. So that's the second point. And then the third point is that all of the judgments really set up quite a tortuous distinction between positive and negative duties, which I think is quite troubling. So overall, where does this leave us? It leaves us with a bit of a difficulty in distilling coherent jurisprudence that sets clear precedents. So that's what I'm going to be focusing on today. So section 8, just a very brief sort of primer on horizontal application. Section 8 is really the provision of the Constitution that is important here. And it's clear that our Constitution envisages that the Bill of Rights can operate not only vertically, that is between state and subjects, but also horizontally between people, individuals and juristic persons. So this is section 8 of the Constitution, and what does a lot of the conceptual heavy lifting is section 8.2 of the Constitution. But the provision is strikingly ambiguous. It's characterized as much by its caveats as by the fact that it potentially expands the ambit of application of Bill of Rights. So, if and to the extent that it is applicable, the Bill of Rights will bind a natural and juristic person. And so what the provision does is that it articulates in principle that the Bill of Rights can apply to private persons, but it does not really give any guidance as to when this would be triggered and whether or how a particular right would be binding. Academic debate about Section 8 has largely turned on whether the application should be direct or indirect. As Bana characterizes it, it's really turning on the form of the application rather than the scope or justification of that application. So just in brief, horizontal application can take place directly through a straightforward reliance on the Constitution, or indirectly, where the rights that bind non-state actors are mediated through subsidiary, more particularized rules in legislation, the common law, and customary law. why is there really any reason to prefer direct or indirect application? I argue that indirect application can almost always provide a solution, and it's not, it really is about instantiating the principle of subsidiarity, which the Constitutional Court has elsewhere insisted on. And the advantage with indirect application is that it mediates the application of the right through a discrete legal rule. And that, I argue, is beneficial for precedent, because we're not just having a fact-bound application of the Constitution. There are some who worry that indirect application is necessarily conservative. I kind of agree with the Van der Walt line that, Constitution envisages rebuilding of legal rules, which are constitutionally deficient. And indirect application is really just the tool for that. So yeah, part of the argument there is that, by first resorting to direct horizontality, the court undermines the idea that the Constitution and its demands should diffuse across all areas of law. Okay, so that's a bit of a primer there. Karabo already chatted a little bit about the judgments a quo, so the restrictive line taken by the High Court and the SCA majority. So I'm going to, just in the interest of time, sort of zoom ahead on that. All the main points really to draw out from this is that the SCA majority and the High Court really emphasized a purely contractual perspective, basically arguing that Section 29, the right to basic education, was not implicated in this case. And the majority judgment of Justice Kachalia in the Supreme Court of Appeal really taking a line that this is an exercise of private power and it would lead to very absurd consequences if it was subject to the duties imposed by the Constitution. Just to briefly map the 4 Constitutional Court judgments, which, yeah, again, Karabo already did quite expertly, but just to really focus on the horizontal application dimensions of the judgment. So there are 4 judgments. The judgment of Justice Theron was a majority judgment. All 4 judgments did find that the school bears duties to the children. So all 4 judgments took an approach that did not insulate independent schools from constitutional duties, which, again, I think that outcome is vital. It's really, really important, especially against the backdrop of the burgeoning independent schooling sector. But the judgments differed quite extensively on how those duties should be given effect. So the Justice Theron's majority judgment really grounded the adjudication in the Constitution itself, not the law of contract. And so it did not engage with whether or not Clause 9.3 is invalid or enforceable. So instead, that judgment took a more narrow approach that the decision to cancel was invalid and made no findings on the clause itself. Part of the argument there was that private interactions have as much potential to violate human rights and to perpetuate inequality and disadvantage in certain contexts as interactions with the state do. Justice Theron's judgment really draws quite a sharp distinction between a claim that is contractual in nature and one that is directed at upholding the children's constitutional rights. And she makes a point that the constitutional obligations here arise not from the contract, but from the Constitution. And as I'll turn to in a moment, I think that's quite problematic. It sets up something of a false dichotomy there. Her judgment relied a fair amount on the ways in which the parties pleaded and characterized their cases, effectively, again, setting up these 2 possible routes, either through contract law or through direct application. And what really grounded the duty for private schools for her? Well, first, she draws on the all-pay judgment to really say that private parties assume constitutional obligations when they perform a constitutional function for a period. And when that is the case, considerations of autonomy, which often play out in the private law, do not feature. And she found that, Pridwin did not have to step into the state's shoes directly to provide a basic education. The point was that it was fulfilling that function. However, he did put something of a kind of conceptual break on this. Her judgment found that Pridwin only has negative obligations and not positive ones. She was at pains to say, well, it's in principle possible for a private person to bear a positive duty in respect of a right in the Bill of Rights, but in this case characterized the duty as being negative in nature. And I'll turn to that again a little bit later in my presentation. And then finally, she said, well, the obligation of private persons is not absolute, and the test can't be Section 36, which is the general limitations test, because there was no law of general application here. She tested the clause directly, and she was drawing on the quite uneasy Barclay's rule. So instead, what was the test that she put in place? It was appropriate justification. And basically, that was a fact and context-specific inquiry that a private person cannot infringe another person's rights without appropriate justification. So that's her judgment, and most of what I'll be chatting about today will be directed to her majority judgment. Acting Justice Nichols had a separate judgment. She looked at the contractual clause itself, which she found was contrary to public policy and unenforceable. So she did frame her analysis within more of a Barclaysian framework. And just, to briefly say, the Barclaysian test is really about the application of public policy in determining whether or not contractual terms and their enforcement are constitutional. So it is more of a classic case of indirect application. So the rights in the Constitution being mediated through a subsidiary rule. And she found, again, that the school does bear these duties, that although private conduct is not subject to the Bill of Rights in the same way as the state is, in part because the state has the benefit of the public purse, this does not mean that private parties are insulated, and that the assumption of constitutional obligations really turns on the volitional nature of the duties that are being assumed or the function that is being played by a private person. She also characterized the duty as being negative and somewhat circumscribed. And ultimately, I think she takes an indirect approach to indirect application approach, although there is some prevarication and uncertainty in her judgment on this. As Karabo mentioned, Justices Cameron and Furneman write a very short judgment, basically trying to say, well, the majority of Justice Turon and Acting Justice Nichols' separate judgment are, there's much more common ground between them. And then Justice Kampepe's judgment, I know Charissa is focusing on. So I'm not going to say much about that judgment, except to say that Justice Kampepe uses Section 10 of the Children's Act to really cut through some of the debate around indirect versus direct application. That really there's this legislative provision that she argues gives something of a complete answer to the case. All right, so as I mentioned right up at the start, I really have three main gripes with majority judgment. So the first gripe is that I think that it risks perpetuating parallel systems of law. So the most obvious understanding of the Pridwin case is that it exactly throws up the intersection of contract law, contractual autonomy, with constitutional rights. But the majority judgment avoided dealing with this intersection. It set up parallel routes that either you can proceed through contract and indirect application or through direct application, relying directly on the constitutional rights. And this was partially on the argument that children's rights don't derive from the contract itself, but from the Constitution. And this point is further complicated by the fact that children were not direct parties to the contract, as Ms. Lowe pointed out. But I think this is a conceptual misstep. It conflates the question of the origin of the rights in question. Here, the rights are sourced in and derive their force from the Constitution, with a mechanism for how those rights are to be given expression. So put differently, I think it's entirely possible for a right to be sourced in the Constitution, but be given effect to in the common law. And ultimately, the majority judgment creates the impression of parallel systems, one system that is shaped by and tested against the Constitution, and another that is autonomous and can be ignored rather than constitutionally infused. And this is contrary to pharmaceutical manufacturers, that we have one system of law that is shaped by the Constitution. It's also puzzlingly contrary to the Bidika judgment, which was handed down on the same day as Pridwin and was also penned by Justice Theron. And in that judgment, she emphasized that constitutional rights should apply through indirect horizontality to contracts. So, there was a chance in the Pridwin judgment for the court to take a harmonized approach to clarify the impact and legacy of Barkhuizen, which is something I see Nerina is here today, something that Nerina is arguing along with Danielle Lindy in a paper, and that this is really a missed opportunity, in part, because the effects of Barkhuizen are quite controversial, and certainly have not added clarity to the debate around horizontality. So that's the first worry that I have with the Pridwin judgment. The second worry is about the test that it sets up for determining whether or not private persons have infringed the rights of others. And so, when would this infringement be justified? And this is important because a different set of considerations are opposite compared to the state. As a duty bearer, a private person acts in her own interests, brings to bear her own competing rights. And on the flip side of the equation, some considerations that are relevant when considering the state are less obviously opposite. So considerations of deference and separation of powers. What the Pridwin judgment does is it closes off the possibility of Section 36 applying, at least in a contractual context, which is perpetuating the misstep of Barkhuizen, and it instead proposes a test of without appropriate justification, which it draws on some case law which actually involved the state as a duty bearer. It's a kind of proportionality test, and in setting this up, the court avoids engaging with a more straightforward balancing test of the kind that we often see in common law rules. So that again, it creates this new test, but exactly the effects of this test are a little uncertain. Then the next worry that I have is around the characterization of negative and positive duties by the majority court. So I think all of the judgments really take quite a tortuous approach to this distinction between negative and positive duties. So, negative duties most obviously understood as constraining or prohibiting action, and positive duties is requiring action. Xu argues, I think very compellingly, that the distinction between negative and positive duties is somewhat overstated. All of the judgments find that the Pridwin School had duties to continue to provide education unless there was appropriate justification not to, and then a duty to afford the opportunity to make representation, so procedural duty, but said that these duties were negative in character. And I think this is somewhat perplexing, and also at odds, as Tom Lowenthal has argued in his piece on Pridwin, with recent developments in other jurisdictions. Now, it's clear that the origin of this difficulty is in the Constitutional Court's very restrictive dicta on this issue in Juma Masjid, basically saying that private persons can only bear negative duties. But this line was retreated from in Daniels versus Scribante, but it's clear that it still had a chilling effect. And the ultimate impact of this kind of line is that applicants and litigants will characterize duties as negative in character, which I think is a pity. It's understandable as litigants, you take whatever tools you can get, but I think that it perpetuates a little bit of conceptual lack of clarity, and really means that it contorts the cause of action and duties that are in place. And I don't think that there's any reason to fear the imposition of positive duties on private persons, especially if we have a good limiting test or balancing process that is in place. Okay, so those were the three main gripes that I have with the judgment. But that still leaves us with a sense of so what. Ultimately, I do think that the outcome of the judgment is vital and really important for regulating the independent schooling sector in general, and then in general, imposing duties on private persons. So the worries here, first there's a coherence worry, and this is especially difficult with the Bidika judgment, which was handed down on the same day, and which contrary to Pridwin, affirmed that contracts must be assessed against constitutional demands through indirect application and public policy. The second worry is about the judgment's precedential effects. So the court does have a tendency sometimes to make sweeping pronouncements, but then limit its precedential effects by basically saying that its judgments turn on context-specific inquiries. And I think that this cuts against the court's stated commitment that horizontal application should progressively transform the law. And we can see both the coherence and precedence concerns already playing out in more developments since. So, for example, in the King and Wilkinson judgments, both of which confront anti-discrimination duties borne by private persons in the context of private testamentary wills. In both judgments, the court was again split in large part on the basis of the form of horizontal application. And so again, we have some issues of coherence and the exact precedential effect of the Pridwin judgment and how that will impact our jurisprudence going forward. And broader, deeper questions still remain. What is ultimately the test for duty bearing? We know that Section 8 is heavily qualified. So when can it really be said that a private person does bear duties in respect of rights, and how much of that is dependent on the right itself? Pridwin leaves us with these tantalizing questions unanswered. Then a final point is, in preparing for today's seminar, I did draw on my SALJ piece, but I also drew on these sources, which I thought were all really excellent engagements with the Pridwin judgment and the effect of the Pridwin judgment. So if anyone's interested in reading further, specifically on the question of horizontal application, I definitely recommend all four of these. All right, I think that's it from me. I'm sorry, Miss, but I think I've run a little bit over. But yeah, really looking forward to engaging with everyone in question time, and then also, of course, in hearing Charissa's views on the Kampepe judgment. Thanks so much.
Thank you, Meghan. That was also fascinating. And thank you so much for mapping out the four judgments. I found that quite helpful. I thought it was just me that didn't understand it properly until you also said, but it's actually problematic, this direct, indirect application and trying to, or perpetuating that there's two parallel systems of the law. And I thought it was something that we've been there, done that. Pharmaceuticals basically said long ago already, and now we are still here in 2021 wondering, how does this work? So thank you very much for that. And I see you cited Narina Ali there with CCR, but yeah, so she's also here, as you pointed out, so we hope to hear something from your side as well. Our last panelist is Dr. Charissa Fawole, and she is currently at the University of Johannesburg, but she's also at SAIFAC, and she did her master's and doctorate at the University of Stellenbosch, and she is originally from Canada. So I'm very glad that you have decided to join us here in South Africa, Charissa. And I'm very excited also to hear what you say about Justice Kampepe's judgment, because for me, what stood out about her judgment was that she brought it home to us that, listen, we are talking about children here. And also what what Karabo pointed out, and it's actually so lovely to say that it's not, children have the same rights, doesn't matter where they are, whether it's private or public. So, but we have to keep in mind, it's the children that we need to keep in mind here. So Charissa, over to you. Interested to hear what you have to say.
Thank you so much, Misfa, and thank you to Karabo and to Meghan for your presentations. Let me just share my screen here. There we go, or nope. There we go. Okay, can everyone see it? Okay, perfect, thank you. So like the other panelists have mentioned, my focus today is actually on one specific judgment. So the judgment authored by Justice Kempepe. And she says something right at the beginning of her judgment. And she says, this case is about children. And this is essentially where I'm going to start and where I'm going to end my presentation today. So I'm not going to go into much detail or background about the case because we've had the benefit of Karabo, who was involved in the case, and also the background provided by Meghan. So basically, what I want us to do is to, again, remember the children, and we can't actually step into their shoes, but to actually consider and appreciate the importance of school from their perspective. School provides them opportunities for development, whether it's intellectual, social development. They spend a majority amount of their time, much of their waking hours, children spend at school. And we also need to appreciate the effort that it takes for them to find their place, to find their friends, to just be comfortable at school. So imagine these boys, DB and EB, have gone through all this, and then through no fault of their own, it's just taken away. And to add insult to injury, they're not even consulted as to why that they have to go to another school and start all over again. So this is where the context we should, I'd like us to have as a focus for the presentation. And then I'm just going to specifically focus on the fourth judgment. You'd ask me why, for example, because this is not the majority judgment. But what's important here is that actually all of the justices in the majority agree and concur with this decision. And in addition, it deals with a very important issue. It deals with the application of the best interests of the child and participation together. So the majority judgment does touch on this, but the judgment Justice Kempepe further develops and focuses on children's rights in this context. And so that's one of the reasons why I want to specifically focus on this judgment. So when we talk about children's rights, sometimes it sounds sort of airy-fairy, and people don't really understand what we're saying when I say children's rights or a children's rights perspective or a balanced model of children's rights. And so I'll just break it down very quickly. There's a way of thinking of children that we used to sort of think about. We call that the welfare perspective. We think of children as objects of protection. We want to protect them. We want to provide for them and care for them. And there's absolutely nothing wrong with wanting those things for children. However, in our contemporary understanding of children, with the advent of the Convention on the Rights of the Child, the African Children's Charter, the law has taken actually a more balanced approach. We definitely understand, and the law represents, that children are vulnerable. They are still developing. They need assistance and care and protection. However, the law does actually recognize that children have capacity, autonomy that develops and evolves over time. So it is this sort of understanding of children, this realistic understanding of children, this balanced understanding of children as bearers of rights that makes up this balanced model of children's rights and our understanding of a children's rights perspective. And we can see that actually throughout Justice Kempepe's judgment. So that's just to give a bit of background, just to see this sort of balanced model of children's rights. So there are two key concepts that are found in this judgment. There is the best interest of the child and participation. I'll speak about them both briefly, just to give some context. So the best interest of the child, for those of us who are involved in children's rights, it's a concept we love to hate because it's very difficult to apply. There's many parts to this idea of considering the child's best interests. And it's found in Convention on the Rights of the Child, the African Children's Charter. It's also found in Section 28(2) of the Constitution, which is what this judgment starts with and focuses on, and it's also included in the Children's Act as well. In Section 28(2), it's a little bit, what's interesting here is it's not necessarily giving a right, it's actually a statement. It's saying children's best interests are of paramount importance in every matter concerning a child. So again, with this sort of formulation, there are sometimes challenges for how we apply this and applying in a consistent and coherent manner. Okay. And so let's just move on to participation. When I say participation, this is a sort of shorthand for what we understand as a child's right to be heard. And that's found in the Convention on the Rights of the Child, the African Children's Charter, and the Children's Act, but it's absent from the Constitution. It's found nowhere within Section 28 or elsewhere in the Constitution. And participation is more than freedom of expression. It is not only giving a child the right to be heard, but those views have to be considered. And it's the weight that's given to the views of the child. It might be age, maturity. Those are some of the caveats provided in Article 12 of the Convention on the Rights of the Child. But a child has a right to express his or her views, and they must be considered. It doesn't mean that the views are determinative, but they must be considered. And this is a specific and very important right that's absent from the Constitution. But with this judgment, with the fourth judgment by Justice Kempepe, it brought this front and center to the application of the best interest of the child. So I have some just comparing and contrasting the best interest of the child and participation. But the major thing here is that even though they are both found in the CRC and African Children's Charter and in children's rights in general, the important thing to note is that the proper application from the perspective of the Committee on the Rights of the Child, which is a committee that basically monitors the application and implementation of the Convention on the Rights of the Child, they state, and it was also referenced in the judgment, that the proper application of the best interest of the child requires the incorporation of a child's views. So basically, a short way of saying this is best interest requires participation. They need to be applied together for the correct application of the best interest of the child. So now let's return back to the fourth judgment. So it's no secret that I actually really enjoy this judgment. I agree with it. And so it's sort of a different thing. Usually when we talk about a judgment, we find things that we dislike about it. But this judgment I'd like to talk about today because it does a lot of very important things for the advancement of children's rights in South Africa and the application. So there's 4 things that I'll talk about briefly in my remaining time. So first, it takes a children's rights perspective. It specifies how the best interest of the child will be applied. It gives content to this application, and it provides that participation should be the default. So participation with best interest is something that should happen automatically, or should be the first point of call, and that is where we should start. And then if we need to deviate from that, then we'll look at maybe reasons why that should be the case. So I'm just going to talk briefly about each of the 4 things. So when I say the fourth judgment takes a children's rights perspective, that's something we shouldn't take for granted. In the earlier judgments of the lower courts, and even just in the interactions with the school and the parents, we can really see that the children in this case who were impacted by the decision most of all were sidelined. They weren't included. And so it's very important, and we can't take for granted that the judgments of the Constitutional Court generally, and Justice Kempepe's judgment specifically, takes a children's rights perspective. And so it brings it back to saying that children are the bearers of rights. They have independent rights that should not be overlooked. They should be included. And also, it takes a substantive approach to the application of children's rights. So with children's rights, it's very easy, for example, especially with the best interest, to sprinkle in the best interest, children's rights into a judgment, but not engage with it in a substantive manner. It could just be that it is there by happenstance, or it's not done in a way that takes a deeper look at children's rights that's more considered. And so there's an article by John Tobin that's very instructive, and he goes into a lot of detail and it explains the different ways that children's rights can be applied. And it could be, for example, invisible, they're not considered at all. It could be just incidental by happenstance. It could be selective, piecemeal sort of application. It could be rhetorical, meaning that we use the language of children's rights, but really it's really a welfare approach. They really aren't looking at children as bearers of rights, as people that are important, that actually have rights. It's just the language that's used, but not actually ensuring that there is actual engagement with the rights. There's a superficial application, and then what we are looking for, what's the gold star here, is a substantive application of children's rights. And we can see throughout the fourth judgment in Pridwin that there's a substantive application. There is a real engagement with the key concepts in children's rights within the Constitution, and they use section 39 to look outside and look at important pieces of international law, specifically the Convention on the Rights of the Child and the African Children's Charter, to bolster the position that's taken. So we can see a clear substantive engagement with children's rights that looks deeper at the rights that are actually provided and their application. So that's one thing that the fourth judgment does. The second thing is it talks about how the best interest should be applied. And so I mentioned best interest is something we love to hate. It's because there's so many ways or facets of it. So it's talked about in the judgment in the majority, and I think also repeated in Justice Kempepe's judgment as a threefold concept. So it's a principle or tool for interpretation, it's procedural right and substantive right. And those are also all very important. But also the fourth judgment acknowledges and it indicates that it looks at the procedural application of best interest, but it also uses the best interest as a standard. So it uses the best interest as a standard to look at and to assess the application or the actions of the school in this particular case. And so that's important because it's a small thing to specify how it's going to be used, but it's an important thing because at least it provides a degree of clarity. We know how the court is going to use this particular concept because there's so many different ways of applying it. Now, the third thing, which is really at the heart of this, is the best interest with participation. So basically, it provides the basis to apply the best interest of the child with participation. And when I say that, I mean that when there's a determination made as to a child's best interest, one of the key factors is the incorporation of a child's views. And so again, like I said, it's not necessarily that if EB and DB said that they wanted to leave the school, that would be determinative of the decision made by the school, but that there must be consideration, appropriate consideration of their views to determine their best interest. There are other factors. It does include the other students. It could include the views of the parents, the rules of the school. There's so many factors that can be taken into consideration. But we see in this, from the facts of this case, that the school made a grave omission by forgetting to include the participation of children. And so what this judgment does is say to us, when we determine the best interest of the child, we need to include the child's views. We need to include child participation. And so, again, it's something that's central. And what's also important is that participation is not part of the Section 28 children's rights. It's not there. And so that's something that it's not as easy to just say, okay, well, it's not, there's not a Section 28(4) that includes participation. So what this judgment does is bring this understanding of participation with best interest to the forefront. And it uses, like I said, Section 39 to look at the CRC and the African Children's Charter, and also looks at the Children's Act and Section 10, which includes a child's right to participate. So this, in some ways, it provides the basis in the beginning for the constitutionalization of a child's right to participate. And so that's a key right for children, because again, it is that's not just that their views are taken, not that they just have to express their views, but their views are taken into consideration. So I think that's just a major achievement for this decision, because we can now, well, I won't get ahead of myself. I mean, but basically, it's something that children and their advocates and people working in the space can look to and use in other ways. So that's something that's important for us to take note of. And so the final thing, what the fourth judgment does, is makes participation a default position. So again, like I said, you could technically consider the best interests of the child and make some sort of determination without considering their views, but that's not the proper application according to the Convention on the Rights of the Child, the CRC committee. And now this case is saying that we should actually start with participation. And it's even more significant because it's not like in other decisions where we were talking about older children, teenagers, you know, and a very articulate 16 or 17-year-old. We're talking about children who are 6, who are 10. And in this judgment, it's based on those facts, still saying, listen, participation must be default, and whether we need to provide assistance in the form of representatives or any other form of assistance for the children to participate, participation should be a default. So that's where we start. And so that, again, brings participation into this Section 28(2) right of the best interests of the child in a very real way. And so that is a very important contribution that this judgment makes. So just to close off, we have this very nice, beautiful concurring judgment. But where do we go from here? Because the fourth judgment is still, I guess my one criticism is that they're very careful. It's very careful to limit the application and say this idea applies in the specific case. This use of best interest and participation applies due to this, you know, the facts of this case. But I think we can be a bit more creative and say, actually, no, we can look at ways to use this beyond the Pridwin judgment. So there's one hint I think we can look at, and that's been given to us within the judgment itself. We look at Section 31. And so Section 31 of the Children's Act talks about major decisions involving a child. And so a major decision is a decision that positively or negatively affects or significantly affects the education, the health, the family and life, or the well-being of a child. So that is quite broad, but it still gives us a criteria to work with. And we can say, for example, if there's another situation, we can say, is this a major decision involving a child? And if so, then our approach to this question should be, when we are making a determination as to the best interests, we must include participation. So what I'm saying is that, yes, this is a concurring judgment, it's not the majority, but we can be cautiously optimistic. We can look at we can look at this judgment, and using it in another situation, we can say, look, in a major decision affecting a child, we need to apply Section 28(2), but we need to apply it with participation, and that makes sure that the children who are impacted by this decision, their views are heard and are considered. So I think that's what I would like to say on the fourth judgment. I would say that it's a judgment that's a breath of fresh air for those of us who are very passionate about children's rights, and that can see that there are problems with the best interest of the child, but we know that it's not going anywhere. It's enshrined in all levels, international, regional, constitutional, the domestic legislation and Children's Act. It's not going anywhere. So this helps us apply it in a way that's consistent with understanding children as the bearers of rights that's consistent with the standards that are in place. And now we have at least a leg to stand on in terms of a constitutional question. We're using best interest with participation. So thank you so much for your attention.
Thank you very much, Charissa. That was fascinating. And I must say, it's quite unfortunate that this link between, or the court linking, or Justice Kampepe linking participation with the best interest of a child, that did not filter through to the main judgment, specifically because, and all the judgments that they all agreed that despite the fact, or the question before the court was moot, it was in the interest of justice. So I would think that it would be in the interest of justice for children, specifically, to always consider participation together with the best interest of the child. Then there are some, I see that, fortunately, so yeah, I'm very glad also that there's some NGO members here. So Farnaz Firavia said from section 27 said that they have written to ISASA regarding that clause 9.3 with the parent-child, or the parent-school contract being terminated. So yes, I hope also that there's some pressure put on private schools, but actually, in fact, all schools, public, private, to incorporate this best interest with the participation. Then David has a question for Meghan. We unfortunately don't have much time for until the seminar ends at 7 o'clock. So David, I will read your question, and also there's if anybody wants to ask questions, just raise your hand. So David said here he has 2 questions / disagreements. A, regarding indirect application that's notoriously vague in how it is conducted, and arguably that it is necessarily so as it applies to values rather than rights. Shouldn't we be thinking about direct application of constitutional rights, which will enable us to think about direct obligations? And I'm not going to read the entire one because I would like to hear from Meghan. The second question / disagreement is that you challenge the application of all pay, specifically because the school was independent, and in all pay, the corporation was not private. So Meghan, I would like to, and I see, yeah, so Meghan, if you can just give us, so let me take some questions, and then I will, whoever it's directed at, hand over to you. Narina Ali from Equal Education, you've got your hand raised.
Hi everyone. Thank you so much for organizing this. It's really been fantastic, and thank you to all of the presenters who've really helped me understand parts of the judgment that I've still been struggling with. I'm not at Equal Education anymore. I'm now at the University of Cape Town. So it's a really pleasure to be able to think about the judgment in retrospect. My question is to Charissa and also to Karabo. Anne Skelton wrote an article a little while ago suggesting that the Constitutional Court's over-reliance on the best interests of the child may be to the detriment of developing the substantive content of other rights. And what I enjoyed about the judgment was that there is a good focus on the right to basic education, in addition to the best interests of the child, section 28. And I wondered if there's perhaps some danger in Justice Kampepe's approach, because it may be too broad. If one thinks of some of the objections or the concerns in the High Court, it was, well, what if we have a contract with parents for a scooter, and the scooter takes the child to the school, and now we want to cancel the scooter contract? Do we have to take into account the child's decisions and participation in that sort of decision? And it seems like an absurd example, but it does raise the point of how far does that principle stretch? And I thought Justice Kampepe's reliance on section 31 of the Children's Act to narrow it to major decisions was interesting, but that section applies specifically to persons who have parental responsibilities. And so it seemed a little bit sneaky there, because the statute is, in that case, very limited, but she seems to be transposing it here to draw out a more general principle. So my interest is in whether there are any potential downsides to how the court has approached the best interest principle, and also if you think that those downsides are tempered by the fact that the court also focused on the right to basic education. Thanks.
Thank you, Nerina. I don't see any other hands there at the moment, so I would ask Meghan, I'm going to ask you first to answer, just with the chronology of the questions, and then the question for Charissa and Karabo.
Great, so thanks, David, so much for those characteristically brilliant, quite difficult questions. I would say, okay, to the first question, really two parts to how I'd respond to that. The first is that, you know, I think that it's a false distinction that indirect application is about values and direct application is about rights. And part of that false distinction, I think, is based on a misunderstanding of how Section 8 and Section 39.2 work together. That basically there's been a little bit of a received understanding that Section 8 governs only direct application, and Section 39.2, which is more diffuse, you know, with reference to the spirit, purpose, and objects of the Bill of Rights, governs indirect application. But I think properly understood, really, Section 8 governs horizontality as a whole. And then once Section 8 has been engaged, then Section 39.2 is one route for that. And this is something Leo Bunzai in his paper on Bidika discusses this aspect of how to understand direct versus indirect horizontal application in a way that I found quite helpful. And so if you have that understanding, then it isn't necessarily the case that indirect application is only working with values and not also with rights. I mean, I definitely agree with the more underlying problem that you have, which is that we do need to be having more rights-based analysis. And that should apply regardless of whether we're taking a direct or indirect route. And then I think in some senses, really, the gravamen of your question was really to say, well, you know, perhaps we should be cutting to the heart of things, which is really not about the form of application, but about the scope of application of the Bill of Rights and the justification for expanding that scope, not just to the state, but also to private persons. And I definitely agree with that. I mean, that really is the heart of the question of horizontality. It's not about the form. It's true in my paper, and today I've defended one form of application, even though I think it's not actually the really difficult question. And so I guess the danger of Pridwin, and to a certain extent academics' engagement on Pridwin, and I'm definitely guilty of that, is that it again refocuses the discussion on the form of application as opposed to what, you know, are arguably the more profound underlying questions of scope and justification. Then on the all pay question, so, you know, the point that I make that all pay isn't analogous. So in all pay, you know, the thing that the court did that was so bold and so novel was to find that cash paymaster services was in fact functioning an organ of state in terms of Section 239 of the Constitution. And that has a massive impact because there's a whole slew of consequences, legislative and regulatory consequences, that an organ of state is bound by, that a private person, even a private person who is bound by horizontal obligations, would not be bound by. And so finding that cash paymaster services was an organ of state was really quite a big deal. The reason that I don't think it's quite analogous with Pridwin and independent schooling sector in general here is that in all pay, cash paymaster services was the gatekeeper to the right to social security. So it was exercising its powers not in parallel to the state as we have with independent schooling sector and public schooling, but really to the exclusion of the state. Another way of putting it would be that the only way that social grants beneficiaries could access their grants was through the system that was administered by cash paymaster services. And I do think that that is a different kind of scenario, and that because in that case it was happening not in parallel but to the exclusion of, the grounds for finding that it was an organ of state were much more easily satisfied than it would be here. And because All Pay turned on Section 239, the organ of state definition, and not on Section 8, the horizontality provision, I think that it's quite disanalogous. I hope that answers the questions. Thanks.
Thank you, Meghan. I'll hand over now to Charissa, and then after Charissa, Karabo can then also just jump in.
Thank you so much for your question, Narita. There's the two parts to the question. I think I'm going to give an answer now, but I think something I'm going to continue to think about. I think the first part with Anne Skelton's article is something I looked at when I was preparing for this. And I think the main point is that the overuse of the best interest is a danger when there actually are other substantive rights that can be applied as opposed to the best interest. In this specific case, there's a determination as to the best interest of the children. There's a decision that has to be made. So the best interest is squarely put. It's directly applicable in this specific situation. So I think that's what I would say regarding that. And then Section 31, I do enjoy that Justice Kempepe did use Section 31. So I do understand that it does talk about parental responsibilities, but it gives us a guide. It gives us an understanding of when we need to look at participation and when it's very important. And so I think the criteria can be very instructive for us. But it's something, to be fair, that I'm going to think about a bit more deeply. So those are, I guess, my comments on your question. Thanks so much.
Thank you, Charissa. Karabo?
I can't seem to put my video on, but I'll just quickly answer because everybody knows what I look like already. It's fine. Narita, very valid points that you raised. And I think that if Justice Kempepe's judgment stood on its own, obviously on the facts of this case, it would be problematic. But I do think that obviously you have to read it together with Justice Theron's judgment, where, as you said, the issue of the right to education is dealt with substantively, and in Section 28, I think she does actually at paragraph 221 say that she feels that it's important to emphasize the self-standing rights of children in relation to that, the best interest and participation. And I think maybe it was because she felt that even though the other judgments are positive and take into account the rights of children, they were not doing it, there was no proper substantive engagement with those aspects. And you're right about Anne's article. I think, Charissa, as a response to your first part of your question, it is true that where there are other rights, one has to try and rely on that and give those content, and obviously that also depends on what people argue before the court. We must not forget that, because it starts with us as litigants. What do we bring before the court? So here, obviously, there was also the interrelatedness of rights, and that's something that sometimes cannot be avoided. So you needed the court to understand best interests as having the procedural and substantive aspects of it, and then linking it with really the participation aspect, which is what Charissa focuses on, reads the two together, and then also then how you link that with the obligation to provide an education. So I think that context will always dictate how you pitch that. And funny, Professor Skelton is my mentor and my former boss, and we've talked about her article because she presented it at one event, and one person who's not from South Africa, even who works on child rights, said, it's true, but there's sometimes where you only have the best interest as a way to actually elevate the protection and promotion of what needs to be done for children. So in a way, I think since she's written it, she's kind of realized that maybe, yes, it's true, but to some extent, we must always leave the space for Section 28 too, to also be read with and be used with the other provisions in relation to children's rights. So it's always going to be that thing that context must guide you. And obviously, in some cases, one would be seeking a proper interpretation of a particular right. You would rely on that and heavily expound on that, and then link it with best interests. So yeah, that would be my response. But things to think about, Norina. Maybe we should also consider an article about some of these aspects. Yeah, thank you.
Thank you for that. It was, yeah, it's quite enlightening. And maybe when you write your article, also ask for the participation of the children. But yes, I see David also, he mentions, because I think for David also, just to give a little bit of background, he works a lot on negative, positive obligations, and in particular also as they relate to the private sphere, specifically business and human rights, and what type of obligations are there, and quite a useful link there to David's book. Then Karabo, I see you've got your hand up again.
Yes, sorry, just one important aspect, and again, it links with what the person who we had a discussion about best interest was talking about, is that you know, when it comes to participation, you know, obviously read together with best interest, we take it for granted that because we've had those provisions in the Constitution for such a long time, it's fine. But actually, and probably that's why Charissa's article is important, we still not getting children to be part of processes where decisions in relation to their rights and their well-being are being made. We know we're not really there. We have these beautiful provisions. We've had nice judgments from the court, starting with Pillay and saying they should have participated, and then the corporal punishment judgment and all those things. But there's a tendency to not really engage with what that means practically when you have to take, and Norina gave the example of the scooter, and you know, just my quick response would be, well, you know, it matters to the children. Maybe they don't want a scooter anymore. Maybe they're happy that you're terminating the contract and they want their own bicycles so they can get themselves to school, or maybe they want a bus, and that's something that in South Africa, even though we have the nice provisions about participation and all that, we're lacking in making it a real thing for children. And not only, you know, on a day-to-day basis, you know, in judgment cases, sometimes we try our best when we're litigating cases where we really, the children directly affected and all that, but we haven't really integrated child participation in everyday kind of decisions that affect children. And there's still a lot of space to develop that and to unpack what it means. And I think we shouldn't shy away from doing that, because currently, when we reflect about children's rights, we're doing an assessment of the use of strategic litigation to promote and protect children's rights. And the big component is that aspect of how do we engage children on our work? Are we really doing it? Are we not? Are we always the people at the forefront with our own voices only? You know, are we doing what EE does, where they bring children's voices through affidavits and give them feedback and work with them on a daily basis? So I think we have a long way to go on that, and we shouldn't take those provisions and what they mean and what they require of us for granted. Thanks.
Thank you, Karabo. Yes, I couldn't agree more there. I think it is, although it is context specific, of course, as everything is in law, but practically, what does that mean? And I wonder, I can't help but wonder if the lack of practically allowing children to participate in decisions that's affecting them, is that not a reflection of the type of society that we live in, where it's a top-down approach of the argument children should be seen and not heard, and the fact that this entire litigation process from the High Court, even before that, when it was still a dispute between the parents and the school, that you know, throughout that entire thing, we reach the judgment, the separate judgment of Justice Kampepe to say, but hold on, what about the children? They should participate. So yes, it's actually, I really do, I sincerely wish that this type of approach that is followed in her judgments filters through, that and that it's a reality, that it becomes a practicality to children throughout the country, that it's not just a top-down approach. You must listen to what I say. You don't have any say. So thank you very much, everyone, for your participation, and especially our speakers. That was absolutely fascinating. I thoroughly enjoyed that. And I have to also, I won't be doing my job as at SAIFAC any justice if I don't advertise our next webinar that you are all invited to and that we're going to send you invitations to. It's the final lecture that will take, or is part of this series. It's a climate change leadership series that we've participated in, and it will be on the 14th of October next week. So where to from here? The role of the next generations and their views on a safe and human world for all. So perhaps also it can link to what we were talking about today, because yes, we are the grown-ups, and the children, how are they going to participate in basically making it a safer and more human world for all, free from climate change, hopefully. So thank you very much, everyone, and I hope you all have a great evening further.
Thank you, everyone.
Thanks. I think we can stop recording now.